Good morning. So the Western culture, when spread in India also, and we have forced to look into so many other aspects of international conventions, international procedures, what to do, what not to do. The one more labor provisions, grant of maternity leave to the woman. That is one of the subject is being now discussed since the matrimonial life is being uh, disturbed or changed to the standard of Western culture also due to so many circumstances, prevailing circumstances. So I do not want to confuse you more, except referring the judgment AR 2025, Supreme Court 2719, AR 2025, Supreme Court 2719, K. Umadevi versus Government of Tamil Nadu. The judgment would help you if any woman comes to you seeking to set aside the departmental order not granting maternity leave. Number one. So far, law students and postgraduate students and other scholars, the judgment would help you to discuss about various international conventions and United Nations organization declarations and so many things, so that you can very well write an article about grant of maternity leave. That apart, the women's rights, so many subject has been discussed here. The facts of the case was that this Uma Devi married a person and begotten 2 children, and thereafter she seems to have been recruited in the state government employment, and subsequently he divorced her husband. The husband was permitted to have the 2 children born to her. Thereafter she married another man, then conceived, and when she sought for maternity leave, by showing a fundamental rights, the department refused to grant, since a fundamental rule 101A which is applicable to employees of Government of Tamil Nadu, stating that only up to 2 children maternity leave will be granted. She approached the single judge of the Honorable High Court of Madras. That High Court of Madras set aside the order of the department and directed to grant maternity leave. Thereafter, then the government went to writ appeal, and that writ appeal allowed, and this grant of leave was simply set aside without deeply going into the subject and rules, regulations, covenants and international treaties, so many things. Then the Supreme Court has stated that since she had another child after entering into the department, refusal to grant maternity leave is against the Maternity Benefit Act. They say maternity leave is integral maternity benefits. So that is what they say. Then you have to, I want to understand you, what are the relevant provisions that the Supreme Court has discussed. They have discussed about the Maternity Benefit Act 1961. Then they have discussed about the protection of life and personal liberty. There they say right to life includes all higher graces of human civilization, rendering fundamental right to a repository of various human rights. Right to life also includes the right to health. So many things. Article 42 of the Constitution about maternity leave. Then they have also discussed about Article 51, where maternity facilities has been discussed. Then fundamental right, FR 101, as I have already told you. Then this right to maternity leave is with payment of wages. Then there was an amendment in the year 2017. After grant of maternity leave to up to 2 children, if she is supposed to conceive third child, the grant of maternity benefit was reduced from 26 weeks to 12 weeks. So that was also discussed. Then they have discussed judgment. Shaw versus Presiding Officer, Labour Court, Coimbatore. Then Universal Declaration of Human Rights adopted by the United Nations in the year 1948. About so many articles, 25, so many articles were discussed. Then Convention, International Convention on Economic, Social and Cultural Rights adopted by General Assembly, 1966. India ratified the said government in the year 1979. So many things have been discussed. The scholar students, the excellent students should concentrate all these subjects. Then they have also elimination of all form of discrimination against a woman. That has been related to this. So then in the year 1999, CEDAW adopted several recommendations, general recommendation about women and health. Then finally, so many other international conventions have been discussed. So this is most important, this Article 21, which was expanded time to time. This judgment says the Article 21, personal liberty, is including reproductive right, that they say reproductive right is also under Article 21. On the exercise of reproductive choices, such as the woman's right to refuse participation in sexual activity or alternative, the existence of use of contraceptive methods. All these things are there. So the elaborating contours of reproductive rights, referring a judgment to X as Principal Secretary. Finally, set aside the judgment of the division bench and also did not agree with the single judge giving reasons to grant maternity leave. They have given a different versions. A fantastic judgment. I hope you would understand the endure and the effects of the Supreme Court judges. Justice Ujjal Buyan. Fantastic efforts. So try to understand and develop your argument. It's all right. I will be very proud if first family advocates argue like this. And I am very happy to observe that young women lawyers are arguing even bail matters politely and interestingly and also successfully. I wish them all success. Best wishes.